So suppose there were a state that said, we're going to flip the default rule so that you cannot leaflet in shopping centers unless you secure permission first. Yep. Would that be constitutionally problematic or not?
The problem there is that oftentimes in the First Amendment context, the First Amendment rules are different than the Second Amendment because they forbid content discrimination and viewpoint discrimination. And a leafletting law often will have some sort of illicit thumb on the scale for a certain set of viewpoints, and so that's
why. Like any leafletting for anybody.
Yeah. So in that,
on any subject.
Right. In that circumstance, this court's precedents on viewpoint and content are so broad it might encompass that. But even if even if you could jump past that, you'd still have to at least have rational basis review. This court in Free Speech Coalition versus Paxton recently said, even for stuff that isn't encompassed in the First Amendment, you still have to have at least some rational basis. Your example would flunk that. Here, Hawaii's done the opposite. There have been no guns effectively in Hawaii for 200 years. The underlying, expectations and local custom, as Justice Sotomayor was saying, was that nobody had to think about guns. What the Hawaii legislature said here in the wake of this court's Bruin decision is, Bruin's a real game changer. And as a result, some shop owners are going to be caught unaware. They're not going to realize that someone might have a concealed Glock on them and the like. And so to vindicate those expectations, they said, we are placing the default rule there on the property owner to say whether they wanted to affirmatively invite guns in. And in choosing where to place that responsibility and that burden, I think it's absolutely reasonable for the state to place it with private property owners whose consent